They say there are two types of companies in the United States, those that have been hacked and those that just don't know it yet. Well, your company's been hacked. Your sensitive, confidential company data has been stolen. Tony Todaro of Corr Cronin will discuss who the hackers are, what the hack can do about it, and how the law treats hackers, the hacked, and victims of hacking. He will also discuss the coming expansion of federal laws, including the Computer Fraud and Abuse Act, giving more tools to corporate victims of hacking, and the parallel expansion of rules and laws holding corporate victims responsible for data breaches. Please welcome our next speaker.
Good morning, everyone. Thank you for having me. I am going to talk about hacking, who's responsible, how they do it, and what you can do about it. So, some years ago, a colleague of mine said always to start with a joke. I figured this time, excuse me, Ed, I'm sorry, back.
Mike, move the mic.
Move the mic up. So I thought it appropriate to hack one from Google Images. So let's talk about the problem. This is a problem that really does affect everyone. Companies large, small, and medium are affected. It is a problem that stretches across virtually every industry, and it is one that is only getting worse. Who's responsible? There are really three classes of parties responsible: cyber criminals, corporate espionage and state-sponsored hackers, and hacktivists. Why do they do it? Well, cyber criminals do it for money. These are organized criminal syndicates that are usually hacking personal financial information of customers, credit cards, credit card information, and the like, and reselling those on black markets for use by criminal operations across the world. Corporate espionage and state-sponsored hacking has a different target. That goal is information. These are hacks aimed at intellectual property, competitive information, and the like. And the third category, hacktivists, these are hacks aimed at causing damage, embarrassing your company, or disabling your company's ability to do business. How is it done? Complicated question, of course, but basically every hack has three elements to it: infiltration, aggregation, and exfiltration. How do you get in? How do you find what you're looking for? And how do you get it out? The most important for our purposes, for security purposes, is infiltration. And I'm going to talk about the three basic ways that your company's information can be infiltrated. The first is a scam called phishing. This is basically a scam done to try and get someone to divulge their password or access credentials. Most people are familiar with the basic phishing scam: a mass email that purports to be from Chase Bank that says there's a problem with your account and we need your password. Chase will never send you such an email, and most people are sophisticated enough to know that is a phishing scam. But the phishing scams that are effective are far more targeted. Spear phishing campaigns where a particular individual is targeted and particular emails purporting to be from a customer, current or prospective, and aimed at gaining access to information. Perhaps the biggest and most well-known data breach in our country, the Target breach, is actually traced to phishing. Target had utilized a vendor, an HVAC vendor, to do work on its internally housed server areas. That vendor had to have certain access to Target's servers and had certain credentials. One of the vendor's employees, the vendor was Fazio Mechanical, apparently became victim of a targeted phishing campaign to him, and his computer became compromised. In the compromise of his computer, Target's access credentials were hacked, and then Target's computers were hacked. So your security is only as good as those that you give the information to. The second methodology is essentially code breaking. This is A hacker finding the remote access to your system. Virtually every company has it, so their employees can work remotely, so their IT professionals can access the system with admin privileges and service the system. A brute force attack is essentially an attack where a hacker will simply try, using an algorithm, repeated attempts at breaking the password. It's the sort of thing that's easy to detect and difficult to stop. It's easy to detect because your system will tell you you've had 1 million failed attempts. But it's difficult to stop because even if you block a particular site, hackers use rotating IPs, so to the receiving computer it looks like they're unique queries. And the only way to really do it is to stop it, or not the only way, but probably the primary way, is to shut down your system, which is not a good option. And even if you do that, the hack will just continue, or the attack will just continue when you turn it back on. This is a good slide on the infrastructure of how a brute force attack happens, but I'm going to skip that so we can keep moving. Zappos was a victim of a brute force attack. 24 million customer records compromised in that data breach. And then the third aspect is probably the simplest hack of them all, and that's where information is left out in the open. Thumb drives that are forgotten, computers that are unlocked, backup tapes that are not secured. One hospital system lost 1.6 million customer records because in the course of the move they failed to secure their old backup tapes. So what does it mean to you? Well, for starters, even before we talk about what it means if you were to get sued, there are costs apart from litigation costs. There are costs that amount to treasure, time, and goodwill. One study says that the average cost of a data breach is around $5.5 million. Target's financial records show that they've spent in excess of $250 million dealing with their December 13 data breach. Home Depot, their quarterly statements say they have spent in excess of $40 million for the September 14 breach. Sony in excess of $15 million from the November 14 breach, and that's climbing. Time, of course. It taxes your internal resources. You need to involve IT, you need to involve PR, you need to involve legal. It can be extremely taxing on a company from a time perspective. And then, of course, goodwill. You are likely to lose customer confidence in your company when a hack is reported, and they are always reported because one of the regulatory requirements is that you alert the media, and the media enjoys low-hanging fruit, so you will almost always see a major hack reported by the media. Finally, regulatory oversight will increase, and this is something that is changing rapidly in the landscape in my state, in Washington. Our governor just signed into law in April new powers for the Attorney General to bring enforcement actions and penalties against companies that fail to safeguard customers' information. AT&T just paid a $25 million settlement in April involving a compromise of one of its call centers and data that was lost there. And then, of course, there's litigation. So the issue in litigation originally was, do you have a duty? Is there a requirement that information that you house that belongs to a customer be safeguarded? And the short answer is yes, the case law has borne that out. Indeed, in the Target case, it was the banks who have brought suit. The banks brought suit claiming they have spent in excess of $400 million replacing the more than $25 million credit card numbers that were compromised. And the court, in a recent decision from December of 2014, said that because Target was really in the position to safeguard that information, it is responsible to do so. Specifically, if you're dealing with credit cards, it's pretty clear that you need to make sure that you are adhering to the payment card industry standards for how to safeguard that information. There is a comprehensive list that they require in terms of how you secure a credit card information, and the bottom line is if you store credit card information, process it, or transmit it, you need to be PCI compliant. If you outsource it, you need to make sure you never touch it. If you do, for whatever reason, customer service, chargebacks, whatever, then you need to be PCI compliant. And the party you outsource it to needs to be PCI compliant, and that needs to be reflected in your agreement with them. Quickly, is this an issue that's going to go away because of the chips that you now all have in your cards, or most of you have? Probably eventually, but the problem is on the merchant side. The merchants aren't spending the money to have the appropriate card readers in place, and even those that do still accept swiping, because the bottom line is it's extremely easy once a credit card has been compromised to put that information onto a magnetic strip. You can do it on your hotel key if you have the very simple tool to do it. The chips, however, are extremely difficult to mimic, but the systems are not in place to have that transformation come about anytime soon. So let's get to the good stuff. How do we defend these claims? The number one issue in dealing with data breach litigation, and this is litigation that is brought by those whose information has been compromised and is suing the company who is itself a victim of a data breach, essentially for failure to safeguard that information. In the old days being 2010 and 2011, the case law was very split. Third Circuit, for example, said, well, simply the loss of information does not constitute an injury until you can show that the bad guys have used that information, until you can demonstrate actual harm. And they found no standing unless that could be demonstrated. The Ninth Circuit saw it differently, saying simply the risk of identity theft is enough to constitute standing for those that have lost information to bring a claim. In 2013, the Supreme Court spoke on the issue, sort of, in the Clapper case, which is not a data breach case. The Supreme Court said that in order for there to be standing, a threatened injury must be certainly impending to constitute an injury in fact. Well, in the data breach scenario, that language got grabbed pretty quickly. And in 2014, a district court in the Southern District of Ohio used the language from Clapper to deny standing to in a data breach case, finding that the facts did not support that the actual use of the compromised information was certainly impending. In other words, you've got to show that they've used it. Well, following that, it looked like maybe these cases weren't going to make it off through the starting line. The Northern District of California then issued a couple of cases in the Adobe case and basically distinguished Clapper, or almost in some ways made fun of it, and said, look, you don't go through the arduous process of hacking into a system, targeting a subset of customer financial data, exporting that to usually overseas servers that are beyond the jurisdictional reach of the US, unless you're going to do something with it. After all, that's why they stole it. And essentially distinguished Clapper and came up with grounds for standing to proceed in that case. In another Northern District case, in the LinkedIn case, they turned to the privacy policy to allow the plaintiffs to have standing, noting that the privacy policy in that case had said that customer information would be protected to the industry standard. So the court said, well, as long as you allege reliance, then you have standing. So what's happened now? This is an issue that's congealed in recent months, and I think we're finally getting some clarity. In the Zappos case from June of this year, the court said, look, putting all this together, there will be standing if you can demonstrate a credible threat of harm that is real and immediate. So there needs to be something tangible in order for there to be standing. And perhaps more importantly, a case from just a couple weeks ago from the Seventh Circuit, the Seventh Circuit said that something can be as minimal as having to get the cost associated, the time and aggravation associated with getting replacement credit cards, setting up credit monitoring and the like. And the Seventh Circuit specifically said, even if the banks pay for the credit cards, even if the company, the victim company, pays for the credit monitoring, that is actual injury, and there is standing. So what do you do about it? Well, You know, being from the Pacific Northwest, ever since the New Yorker article came out, we all have emergency action plans for when the big one comes. You need to have a plan. You need to be ready for it. Put in writing a data breach response plan, a plan that articulates who the parties are that are going to be involved. Obviously, you need people from legal. Obviously, you're going to need people from public relations, and you're going to need IT staff. Delineate the responsibilities of each and the steps to be taken in terms of preserving data as soon as a breach occurs, in terms of giving the required notices that are required under state and federal regulations, and in terms of having at the ready a media response, because you will get picked up. In addition, have somebody in charge. There needs to be someone. If you don't have a chief security officer, then someone in the legal department, not the GC, but an associate or assistant GC to spearhead if there is, unfortunately, a data breach. And finally, consider insurance. You're going to hear more about that later today from Linda Wolf, but Target was able to recoup over $90 million of its losses through insurance. So there is a path to making this an insurable risk. So that was all defense. What about affirmative opportunities? Obviously, if you know the hacker, there's lots of things you can sue for. You can sue for trespass to chattels, misappropriation, and so on. But there is a statute that's really the most significant in this area, and that is the Computer Fraud and Abuse Act. It was enacted in '84 as purely a criminal measure to deal with hacks of government computers, but in '94 it was expanded to give a private right of action, and in '96 the scope of protected computers was expanded to include any computer involved in interstate commerce, which of course is every computer. So CAFA has with it not only good remedies, but can be a tool for discovery. And in a very interesting case brought by Uber Technologies, where their driver database and vehicle license plate database was hacked, Uber filed against John Doe. They didn't know who hacked, using CAFA, and issued third-party subpoenas that their experts told them would help them to identify who was responsible for the hacks. Well, Uber prevailed insofar as the court did order one of those parties, company GitHub that had resisted the subpoena, to produce and turn over thousands of user files over GitHub's objection, saying, no, this discovery is necessary to help Uber identify who hacked them. So at the end of the day, this is a problem that will persist. It is one that may not be preventable. It's correct that if you haven't been hacked, it's only a matter of time. But there are ways to protect that risk, to be ready for it, and there are affirmative steps that can be taken at the end of it. So thank you all for having me. I've enjoyed being here, and I hope to meet several of you over the course of the day. Thank you.